Public Protector Advocate Busiswe Mkhwebane is seeking an urgent interdict to halt the parliamentary inquiry into her fitness to hold office. It's after a Democratic Alliance motion was granted by National Assembly Speaker Cathy Mohlahlana. She's also challenging the new National Assembly rules governing this type of inquiry. We're joined by the University of Cape Town's Public Law Associate Professor Cathleen Powell. Professor Cathleen, good evening and thank you so much for your time on News at Prime tonight. Firstly, let's discuss the first part of this application by the Public Protector, which is the one being heard today around interdicting the parliamentary process, and look at the arguments that her advocate Dalimpofu has put before the High Court in terms of the behavior of the National Speaker, Cathy Mohlahlana, and the vendetta that he believes the DA has against the Public Protector.
Those are very poor arguments in law, because they are arguments about motivation. So even accepting that the speakers behaved appallingly, that could be a separate matter that should be separately dealt with. It has absolutely no bearing on the legal quality, the legal validity of the proceedings which Parliament is currently carrying out under the Speaker, and it's her duty to pass this issue on to the Portfolio Committee that must consider it, that is considering removing the Public Protector. The Constitution sets out a process for removal of the Public Protector. The National Assembly recently went through the process of setting up a process for the removal of the Public Protector, and one of the reasons they did that was partly because it's been found necessary in the case of the President. There must be a process for his removal, but also because the Public Protector herself complained that there was no process set up for her removal. So they've set up one, and they're starting to try use it, and now step one of the Public Protector's argument is to try to stop the process entirely on the basis that the people who are involved in it don't like her. Now, that's not a constitutional argument.
So what would Advocate Mpofu need to show here in order to have this case have any chances or prospects of success?
Quite frankly, I don't think she has got many prospects of success. Well, let me rephrase that. I don't think she has any. But bear in mind there are two stages to this challenge that she's bringing. One is to attempt to get the process stayed while she challenges it on the merits. So that's getting an interdict so that it doesn't go ahead while the court considers whether it's allowed to go ahead at all. Now, I think on the first stage, on the first point, she has absolutely no chance, because there is nothing stopping the court from deciding later on, after the process has already happened, that for some reason it was unconstitutional. But there's absolutely no reason for the court to stop this process from even starting, when it is Parliament's right and duty to exercise oversight over the Chapter 9 institutions, including the Public Protector, and Section 194 of the Constitution specifically sets out how a Public Protector can and should be removed if the criteria are met, which include incompetence and misconduct.
Professor Powell,
sure. Sorry?
Maybe if you can just explain for us, because usually when we do have, let's say, different office bearers that are involved in potentially disciplinary processes within their organizations, they tend to go to the court. And what that often does is that it stays any process that is taking place within the organization while the court awaits its outcome. So even if she fails on part A of this application, does it mean that by simply filing a motion to question the constitutionality of this process to remove her, does it automatically mean that Parliament then becomes disabled and can't do anything about her fitness to hold office until that court process has been seen through?
Well, that's exactly what Part A is trying to achieve. It's trying to stop the process from going ahead while it's being challenged. Now, if that's done within a work environment, it can have more strength than more force than what Advocate Mkhwebane is currently offering, because if an employee tries to stop a disciplinary process on the basis of certain procedural flaws in that process, then there would be more of a reason to stop it, or at least to stop the person from losing his or her job in the meanwhile. That makes sense. The problem is that the public protector is trying to stop a constitutionally mandated process with no reason at all. She cannot give a reason why the NA is interpreting the Constitution incorrectly. She cannot say what's wrong with the rules that have been set up to go through the process of checking whether she's unfit to hold office. She can't actually bring a substantive reason. So I don't even think she'll succeed on the merits, but certainly she's offered nothing that shows why Parliament can't go ahead. It's not as if she loses her job as public protector until Parliament's finished with its process. So she's suffering no prejudice in the meanwhile for the case simply to proceed in Parliament, which is where it's meant to happen.
So effectively, should she lose Part A of this application, which is to interdict the entire process from getting started, does that mean Parliament would legally have the room to continue with its own process, even if she does take it on appeal? And we know how long those processes can often be.
Indeed, what could happen is that she loses on Part A. The court says, no, we're not interdicting it. So Parliament then starts the hearing using the process that it's set up. While it's doing that, she can bring a challenge to that in court. So the two could even proceed at the same time. I suppose it's possible that the court would say, look, you haven't yet demonstrated any prejudice. We're going to wait until this proceeding is over before we will hear it. But it may be that the court's prepared to hear the challenge at the same time as the NA actually carries out the process.
Of course, that makes things a lot more complex, doesn't it?
Well, yes. In effect, it's like having the Zondo Commission and a prosecution of the same matter at the same time. But it does mean that Parliament is not stopped from doing its job. And one of the issues that the court's going to be very aware of here is separation of powers. It is not meant to interfere in Parliament's carrying out of its own duties. The Constitution specifically says that it's up to the NA to set up its own proceedings to do its job. One of its jobs is a Section 194 inquiry. If evidence is brought, prima facie evidence, that one of the Chapter 9 institution holders is not fit for that office. So it's doing that. The court doesn't actually have a right to interfere. And certainly Advocate Mkhwebane has not produced any reason for the courts to interfere in Parliament doing its own job.
All right. And it sounds like in many ways this continues to be a precedent-setting matter. Well,
yes and no. I think it's going to be another case that the public protector loses, quite frankly. Much as the challenge against her, or the complaint that's been brought, that's being considered by the National Assembly, is that she doesn't understand the law properly. That's one of the challenges. And this particular challenge might just well end up proving that point a bit better than she would like it proven. So if that happens, it's not really precedent setting. It's simply yet another case in which the public protector cannot make a legally cogent argument for her position.